exposed. I mean, they take my son and then they give my son poison. It doesn't even make sense. We're a land of the free, home of the brave.
That's just what we're going to do. Just like you got a prescription, you can do it anyway. You do not have to have one.
Yeah, I don't know what's going on. Yeah, you see what I'm saying? You don't even talk to me. He's representing my son. And I haven't spoken to him at all. I haven't spoken to him one bit. And he's supposed to be my son's representation. Right. Right. And they're not, none of that really progresses. They'd already taken my son. You know what I'm saying?
Are you, family? Okay, we're gonna have to ask you to step out because you're not actually a party in the case.
Wow.
But then,
I can't have
yeah.
a witness to
Yeah,
what's
sorry,
going on.
they're closed to proceedings, so if you'll just have a seat out in the hall.
Wow.
So he's not allowed to have any family or anybody in here with him?
I mean, we can, if anybody objects, and at this point, it's set for a pre-hearing. So until he can ask Judge if you could be allowed in here.
Yeah, can we do that?
Yeah, so go ahead and have a seat out in the hall, and then when Judge comes in, he can ask, okay?
Ask him.
Yeah, I will. Man. This is wild. So everybody's in here is on the case. So who are those two right there?
All right. The district of Penn County is now in session. We all will go accordingly.
Who are they? Who are those two? They're not on the case, are they?
I don't know this yet, they keep out terms under you being in court, understand? Stepping off the wrong way. Are the parties present, ready to proceed, the matter of Miles?
Your Honor, Sarah Kennedy present, currently representing Mr. Hunter. He has notified me that he wants to represent himself, and he does not want me to proceed on his case.
Or Anthony Seaberg on behalf of the child, present.
Who else do we have in the courtroom?
Justin Michelle, the district director for Logan, or just Payne County DHS.
My name is Michelle Burdick, and I'm the permanency planning supervisor.
Your Honor, my name is Andy Rose, and I am currently the caseworker just assigned this week.
Matter appears for purposes of the pre-trial.
May I speak? Alicia's not here. She's listed as Alicia. She's listed as a party on the case, but she's deceased. She's not here for a present. So how can we go forward if she's listed as a party on the case?
Are you talking about,
In accordance to the What I received, which was supposed to be the discovery, she's listed as a party on the case.
She's not a party, she's the mother that.
I know, but it says,
All right, we're not gonna play this game. When I'm talking, you do not interrupt, all right? Plain and simple, when I'm talking, you do not interrupt. I will let you speak. She is not a party to this case because she is deceased. You, according to the information, are the natural father, and that's why you are party to the proceeding. So, Mr. Hunter, do you wish to be heard concerning your motion to have Ms. Kennedy no longer represent you in this matter?
I do. I still would like to address Alicia being listed as a party while she's deceased. I mean, this is on the discovery paperwork that I got from the clerk, so I'm not understanding if, a party is supposed to be living and present, how can she be listed as a party and she's deceased? She can't speak for herself, nor can she speak on our behalf or our son.
She is not a party to the lawsuit, so you may continue. You wish to be heard concerning your motion to have Ms. Kennedy not represent you?
Yeah? Yes?
Then I'll hear you this time.
I'm entitled to represent myself in accordance to the Constitution. So,
Mr. Heine, you are correct. You are entitled to represent yourself. I don't recommend that because, as you know, if you represent yourself, you'll be held to the same standard as an attorney. You have to follow the rules of evidence and comply with them. You understand that?
in accordance to the,
Listen to the question. Do you understand that?
I do not understand. I'm reading the documentation from the rules of federal civil procedure that are saying I don't have to be held to that constraint.
I will grant some latitude concerning that because you are per se, but I would still require you to follow the rules of evidence and comply with the rules of evidence. That's why we have attorneys to represent individuals, that you do have the right to represent yourself. Is that what you want to do in this matter?
It's necessary that I do so because there's a conflict that's going on where the attorney is not a public defender. She's a part of the Bar Association.
Well, all attorneys in Oklahoma are part of the Bar Association. It's mandatory required. You know that as well. We've been through that before with Ms. Figg.
I'll have to object to that because the website says it's a voluntary association.
The website's wrong. It's not a voluntary association. It's mandatory in Oklahoma.
I'm just telling you what the website says, you know what I mean?
All right, are you sure you want to represent yourself and not have counsel assist you in this matter?
Yes, I'm sure of that because again, there's a conflict there. She's a part of the Bar Association. And there's no public defender.
The court will release Ms. Kennedy as representing this matter. Are there any pre-trial issues that need to be addressed at this time on behalf of the state?
The state's provided discovery disclosures previously. I think Mr. Seeberger has them. I know Ms. Nip stated that she's numbering and copying everything. We'll get the bulk of the documents to him in 10 days.
Anything on behalf of the view, Mr. Hunter?
Yeah, I requested the
When you talk, need to stand and address the court properly.
I requested the discovery, and this is what I was told the discovery is just these.
Here,
sheets of
here,
paper.
minutes from the court proceeding.
Yeah, I requested for the discovery. I wrote a writ for a discovery, and this is what I was told is a discovery.
That's not discovery.
So,
What you can,
I have an extra copy that I provided.
okay, this is something else. I also requested for the body cam footage that was taken that day in reference to the discovery as well. Because there were police officers that were utilized in order to enter into my home and take my son as well as take me.
that is not a part of this proceeding.
The district attorney denied me the footage. When I called the police officers for the footage, they said that the district attorney is the ones
You
that...
might be entitled to that evidence in a different type of lawsuit, but as part of this lawsuit, that's not relevant to these proceedings.
Yeah, I mean, it would show the, the unnecessary actions that were carried out, and then whatever else that may have been said in reference, because the body cam footage is public footage, which is on all the time. So at least I'd be able to account for whatever was spoken on in reference to Sarah Oliver and Amanda LaHoo and their conversations with the police officers that were there. That's the main reason why I requested that body cam footage as evidence for my case to help speak on our behalf of my son and how we're doing what we're doing, the inconvenience and the infringement that occurred on our right to privacy. So that's why I'm requesting, all the things that were involved for those 2 days, so I can have the proper evidence to defend myself and defend my son, to get my son back.
The issue, Mr. Hunter, is whether or not your son was being deprived based upon malnutrition. How they handled you, what they did, might be very relevant for a different type of lawsuit, like you indicated. It's not relevant for this particular proceeding. The issue they have to prove is those things, whether or not your child was being deprived, whether or not was malnutrition, malnourished, based upon what they alleged.
Right.
How they handled you, how they treated you, you might file a different lawsuit, and that might be relevant.
It would show though how their procedure they went through to even take him, because they had no evidence of malnutrition, of neglect.
That's what they've got to prove.
Right, but they've taken him from me before they've proven anything. So how's that going to stand? I can understand you make the allegations towards me and I come to court and we have this conversation, or even whatever mediation to go to them and have this conversation of, well, there's allegations against you in reference to the referrals, which are just, voluntary documents, the recommendations, which again is just a suggestion, advice, which is just guidance, what I'm saying? The services is something that they actually are providing to help, so it would show the fact of, were they actually providing services to help, or were they maybe doing something unnecessary to breach the privacy of my family.
I know your request at this time as it relates to body cam videos, the court finds that they're not relevant for these proceedings and denies that request. Are there any other pretrial issues that need to be addressed?
Yes, Your Honor,
Hang on. The state should be the one that makes arguments to the court, not the department. So does the state have anything they need to address before we go through?
Your Honor, not in pretrial proceedings for adjudication. I do think that DHS has some concerns regarding visits that the court wants to take out other parties to do.
Well, I hear that from you, Mr. Attorney Brennan.
Yes, sir. I think the concerns during visitation, and again, Ms. Michelle from DHS may be able to explain it a little bit further if you wanted to hear from her, but I think concerns over what the baby is being fed at visitations, or at least attempting to be fed at visitations, the amount of time being spent with the child, and what is being said at the visitations. I don't want to say threats, but maybe describing actions that are going to be taken with the child, including taking the child from the visitations, including police intervention. I think all of those things are concerning
Mr. Hunter, I have reviewed a report from the department stating those things that the state just indicated. I did grant you the right of visitation until we've had a hearing. But if you're going to do the things that they've alleged that you've done during those visitations, then I will not allow visitation until we've had a hearing. Do you understand that?
I'd like to speak on those things, please.
Okay.
Yeah. So the things that they're talking about is, one, me referencing the fact that they have violated my rights. I issued them a certificate of liability violation warning in reference to the violation of 18 U.S.C. 242, 18 U.S.C. 245, and 42 U.S.C. 1983. Also, again, there is no order stating that I can't give my son natural food. I'm bringing him watermelon, I'm bringing him cherries. These are things that my culture, my heritage grew up on, lives on. We don't eat processed foods. We don't eat quote-unquote formulas that have BTHQ in it, that have, all these other, as Ms. Kennedy was here that day before, and she asked you to tell them to give him food, and she said chemicals. And we don't feed our son chemicals. We don't eat chemicals ourselves. We don't eat the processed food. We eat natural foods from the earth. That's how we carry it. So the question at hand is, how is it that Mother Nature's food and breast milk from a woman is wrong in comparison to a man-made formula that's over-processed and has chemicals in it? How is my son going to benefit from that? And then as well, from being in whomever's care he's in, he's got scabs on the top of his head. Now, I made a dress about it the first visit. The next visit, it was cleared up. You could still see the remnants of the scab, but he's also balding. And there are things where he had dirt in his hair, little dirt gombles. His nose now is full of dry snot. And I know that's coming from the processed foods because he's never had that with me. He's never had a dry nose, a snotty nose. He's never had, as it was called, cradle cap, because his hair is now gone back. His hair is growing. His hair is growing. I'm putting black seed oil, I'm using walnut oil, I'm using coconut oil, the derivatives of the planet to take care of my son and myself. So, the invasion of privacy is bewildering, and especially because, noting that Pierce versus the Society of Sisters, the court has held that the Constitution protects the sanctity of the family precisely because the institution of family is deeply rooted in this nation's history and tradition. Even Oklahoma versus Skinner, where marriage and procreation are among the basic civil rights of man. Care and nurture of children by the family are within the private realm of family life, which the state cannot enter. And then based off of the very language that they're using, where a referral is an act of referring someone or something for consultation, review, or further action, that doesn't give them the right to come into my house or to utilize the police to bang on my door, as well as consideration, careful thought, typically over a period of time.
Those things you keep listed are things that need to be handled in another lawsuit you should file. This matter deals with your child and the allegations in the petition. Right now, the department has temporary custody. You will not be feeding the child anything or put anything on the child until you have custody back. So during your visitation, if you visit with the child, play with the child, but if you're going to feed the child, they don't have a lot of visitation, all right?
I object to that. I object to that.
You can object all you want. I'm ordering that.
It's my son though. They needed my consent in order to not vaccinate him, so why wouldn't you need my consent to feed him? And then the foods that are being fed, Your Honor, they're chemicals, Your Honor. They're chemically processed foods.
Until I had a hearing on the ultimate issue, the custody of your child is with the department.
I just request that you at least have them get the breast milk. He has a 20-year prescription of breast milk with the Mother Milk's Bank, and that's what I've been giving him, is breast milk. I'm requesting that. Please allow him to have the breast milk.
Does the state have any knowledge or response about that?
Well, I know DHS is addressing they're having transportation issues with the breast milk. I'm not in detail with that, but I think that they've attempted it. They're having issues, I'm understanding correctly, keeping it cold and being able to have it.
It's frozen. When you go to pick it up, it's actually frozen, and you can put it in the freezer and just let it unthaw within the refrigerator.
Where are you getting that?
I was getting it from Oklahoma City, the Mother's Milk Bank in Oklahoma City. So I was driving out there. It's a 2-hour drive from here to out there. Or excuse me, it's an hour drive, but back and forth is 2 hours. And I'm getting the bag's about that big. It has about 40 or so breast milk bottles within it, each about 2 to 3 ounces of breast milk, each container. And I was splitting the breast milk up with coconut oil, and he was gaining more weight because of that. So I would definitely like for him to continue on at least the breast milk, because again, he has a prescription, from the mother's milk bank through the hospital.
If the court ordered to go to this specific place and get this specific milk, I think that they'd have to make arrangements because it's 2 hours away and it needs to be, remain cold when it becomes frozen. I just think there's transportation issues in doing that, repeatedly. DHS could make attempts to do that if that specific thing needed to be.
The court understands part of Mr. Hunter's position in that he will have aggressive numbers to the formula. And I understand that as well, especially with the formula situations going on. So I'm going to order the department to at least inquire into that and see if that's a possibility. If you're able to facilitate it further with them, I'll allow that to work as well, okay? Anything on that, Mr. Seaver?
Your Honor, the only thing I would have on, for pretrial purposes is that I have not filed a formal discovery, but any discovery I would have in this matter would not be anything in addition to what the state's provided.
Anything further, Mr. Hunter, at this time?
Yeah, man, I mean, I'm seeking my son back to finish building my family, my dynasty.
We are set for trial on July the 5th, and that's when I'll hear the evidence. I can make my rulings on this matter.
Can you give me my son back and we go to trial on July? I would really like more visitation time with him, because one day out of the week, and he's a premature child at that, is not allowing me to build the proper relationship with him.
If you will do things properly and not do what you have been doing allegedly.
They're not giving me any way, man. They're not giving me any leeway. It's my son, man. It's the most important person on the planet to
If
me.
you don't like to have a hearing, and I can roll on the evidence, that's the way it's got to be.
This
Okay?
is wild.
That's why we're set for July the 5th.
This is wild, man.
So, I would, if you will,
I'd like to be able to see him every day.
I don't think that's going to be a possibility.
I mean, that's what that's what we were doing. You know what I mean? That's what we were doing. At least, or maybe 3 times out of the week until, it's necessary that I see him and build my connection with him. He is my child.
We'll see where we're at on July the 5th. Mr. Hunter, you've had some individuals on your behalf send me some emails.
Right. Oh man, I'm supposed to ask for my friend to come inside. She was sitting outside.
That's not proper or appropriate. I should not, just like you trying to talk to me about chambers, it's not proper or appropriate. That all has to be done in court, okay? So what I'm doing is going to give everybody a copy of those emails so that you'll know what somebody sent me. But please don't have people send me emails.
I mean, they
You
felt-
get emails, you can present them in court.
They
okay?
felt compelled to send them to you. They wanted to, make sure that you got it. So I have nothing to do with the properness of, an individual feeling compelled to speak.
The
And
way it needs to be done is in court, so let those individuals know, okay?
well, they won't be able to be present. Those that sent the
I'm
stuff.
trying to present something that needs to be done in court, okay?
I do have a question in reference to the collaterals that they have. Are they going to be present?
In reference to what?
The collaterals that are listed in the assessment, that are listed in the affidavit, the collaterals that are being used to validate, as referrals, the collaterals that gave referrals in order for this situation that happened, are they going to be in the courtroom? Have they been subpoenaed to be present so they can testify as to what
I
happened?
don't tell the state how to present their case, just like I don't tell you how to present your case, so
That's, is it a question of proper, right? Shouldn't the collaterals be present as witnesses to say he did such and such, I was there, I saw, etc., so have you?
that may be what they need to prove the case, but I'm not gonna say their name until they present their evidence. So that's why you're not gonna have an attorney to kind of do subpoenas and stuff like that as well, maybe,
Yeah, I filed discovery and they're not even giving me discovery,
give you a list of what they intend to present, which is what discovery is.
For the district attorney, would you be able to have them release the body cam footage? Because I did file for that.
I just told you I'm not voting.
No, I understand that, but the district attorney is holding the body cam footage from me getting it, so I hear you saying you won't look at that in the thing, but I still need the footage. You know what I'm saying?
I'll look the records after the police department, see if they will provide it.
That's what it normally is, right, open records, isn't it? So I would have to do a FOIA instead, because the district attorney is saying I can't get it.
DA's not police department, police department's a different entity.
Yeah, that's what I'm saying. I know Corley, I know Judge, but the police department is telling me that the district attorney is telling them that they can't release the footage. And I'm asking for the public record of what happened that day.
And you have to address that with the city attorney and the city.
City attorney as well, man.
Wow.
Look,
Have lawyers and lawsuits.
Look, the officer that I spoke to told me that the city attorney and the district attorney told him that he can't release the footage to him. And that doesn't make sense when I filed the proper open records document in order for it to be released.
Like I said, there's different procedures for that, not this particular case.
Right, yeah, I hear you, so I'll have to file a FOIA. I get that, because they won't release it, right?
I don't know what they're doing.
Yeah, I hear you. They won't release it.
All right. Anything else that needs to be addressed at this time on any party?
Yeah, I would like for Alicia's name to be taken off as a party listed. She's listed as a party to the case. So I would like for her name to be taken off, because as attorneys are listed and represented parties, the state doesn't represent anyone. The state has there's no representation for anyone on the state.
This is the proper document, it's a petition. She is not listed as a party. Party is your son.
Where's what I was just given?
Mr. Rose mother and then deceased.
Which document are you talking about?
Petition to adjudicate child crime. That's charging information.
The petition to I don't think I have that one.
So that came before the very first time.
Oh, okay, that's the newest petition that they made, right?
Filed on April 27th, 2020.
Right, because the first one was Amanda LaHoo's own petition, and then the state made a petition
This is the
on
charging
themselves.
document, okay?
Could I get a copy of that, please?
You were given a copy in court.
Yeah, I don't recall.
You can keep one downstairs.
Yeah, I was gonna do that, yeah.
All right, we're set for trial on July the 5th at 9 o'clock. So all things will remain in effect, custody will remain department temporarily at this time. We'll go from there.
And can you put a note, we work together so he can get the breast milk?
I'll make that order at this time. All right. So with that, the party may be excused and will be adjourned this time. Mr. Hunter, this is your copy here.
But this wasn't even about me getting my son back. This was just about continuing on. Right. I can't believe how people want to be like this. You take my son, you intervene into my life and take my son, and now I gotta be the one. You got my son, so how are you supposed to prove that I'm neglected so you can take my son, not take my son?